The Honourable, the Vice President.
Senator Haynes.
Thank you, Mr. Vice President. As I rise to contribute on this amendment to the Sexual Offences Amendment Bill 2019, I would just like to start with a story from the United States, a story that occurred an incident that occurred in 1989. And the reason I'm starting here, it is because this incident is what prompted the sexual offenders registries in the United States, as well as the sexual offenders notice. So this is a story of a young Jacob Weatherling who went to a convenience store with two of his friends, and they were held up by a gunman. This young man, Jacob, was the youngest of the three, and he was subsequently kidnapped by the offender. His mother, Patty Weatherling, led a crusade. She led a crusade with the National Guard, the FBI, to find her young missing son. And she was told, eventually young Jacob was found murdered and sexually abused. And the police told her that if only they had a list of suspects, a registry, that they would have at least had a place to start. So and this prompted the establishment of in America, the nation's first public sex offender registry. Now this is the beginning of an article, a scholarly article on rethinking sex offender registries. And they started there because they noted that given the emotion and the context in which we are always asked to examine things like sexual offender registries or any of our legislation dealing with sexual offenses, the way the public policy conversation is framed and contextualized, it is almost impossible in a political sphere to have a conversation that is not emotive, or that we would look at the data and the statistics in a logical manner and ask, are the things we're doing working right? They said that usually when we debate anywhere worldwide sexual offenses, we are told about the horrified parents, people who are scared for their children being snatched, and that sexually oriented crimes committed against children are one of the most deep-seated cultural and perhaps the most innately human reasons, the violation of our human dignity. And therefore, Mr. Vice President, we as legislators are constantly asked to confront two things. What is my opinion? How do I feel? What would I like to see happen? If I could do anything, what would I do? And then, because we have the people's business to take care of, we must say, what does the research say? And what is the data telling us? And are we doing the right thing? And so I started there because in my contribution, I hope to address a couple of things. And I had hoped when the Attorney General piloted the bill that I would have heard certain things, and I'll get to those. What specifically do we hope to accomplish, specifically, with this amendment? The amendment placed before us, once we've established what we specifically hope to accomplish, does the amendment before us achieve that goal? What is the research telling us? And I have compiled 4 different data sets, and for the benefit of Hansel, I would read the sources into the record, but I've also compiled a works cited sheet so that it would be easier for the record keeping. And when we as a parliament agree that we have found a good solution to our articulated problem, how are we going to implement it, and are the things in place to implement it? And that is my suggested approach from my that's my approach in my contribution. And when the Attorney General opened the debate today, we started much in the way that the debate started in the United States. I heard his anger, and I agreed with it. I heard all of the emotion behind it, and I agreed with all of it. But the question of the legitimate aim of the legislation was not answered. And in the event of all the consultations that the Attorney General spoke about, and the 19 years in coming, and all of these things that we ought to be doing, I still had my very first question unanswered, which is, what is our intention here? Is it to protect children, or is it, in essence, punitive? Are we saying we are so aggrieved by the crime that you have committed? We as a nation are so angry that we want to find new ways to punish you for what you have done. Because the statistics reported by the Attorney General gave us numbers from 2015 to 2018 in terms of the numbers of cases reported. And in that vein, continuing, the Attorney General said hardly any of these, with the statistics coming from the judiciary, hardly any of these were dealt with. And therefore, and I wrote down here, then therefore most of these cases, the numbers that were meant to move us to be so angry and so upset by what is happening in our nation. What is this Trinidad and Tobago that we live in? The vast majority of those just will not be captured by this legislation. This legislation does not treat with the vast majority of the cases that the Attorney General spoke about, simply because there have been no convictions. And the Attorney General went through the pieces of children's legislation and to say that this was not done in a silo. And this is part of a package that is meant to protect our children. Again, though, having examined the elements of the legislation as well as the research, I have not seen what the protection element of this legislation is as yet. The Attorney General asked us to, prior to that, in asking what has been done in the 19 years, what were the statistics, the Attorney General himself noted that what were the studies that were done. And that was one of the things when he noted nothing was done in that area. And that also concerns me, because in my preparation for the debate, I could not find any local studies done. So I had to take the legislation as proposed here, find similar sexual registration and notification legislation elsewhere. I landed on the legislation in South Carolina, just try to see how close it was, to see if we can, and the societies are still ultimately different, but I think some of it can inform what we're doing here today. And that being said, I would just, from the onset, say I have no problem at all with our sexual offenders registry. But I want to disaggregate the two things here. In this sexual offences amendment bill, we're asked to do two things. Well, we're asked to do a number of things, but things that are drawing the most contention are the National Sex Offender Register. And where I have some issue is Section 41, which is the trigger of the notice, where sexual offenders, your information is given to the public. So I will go into much detail later on that. The Attorney General noted that he consulted with the Minister of Foreign Affairs, the Chief Justice, the Minister of National Security, DPP, the Minister in the Ministry in the Office of the Prime Minister, Children's Authority, the Police Service, Prisons, and the Law Association. Helpful in this debate, I think, Mr. Attorney General, would be if the submissions by these persons and how it filtered into what our end product is today would have been helpful, I think. Because if we are here and we're asked to discuss the amendments, I would like to know what those contributions are, so as I weigh in on where I stand on this legislation, and I think that would have been helpful, which is perhaps why the call for a GSC. because then these things would have been filtered out in the public eye, and people get to make a more informed assessment and more informed judgment in terms of what we're being asked to do here today. So I am as passionate about the issue. Sexual crimes do trigger a lot of emotion. The Minister of Labour, in her contribution, also went into a kind of detail to trigger a lot of emotions. But I have to agree with Senator Choate, where when you are legislating, you have to do it with a level head. You have to be able to separate yourself and separate your emotions and your instinct and say, are you doing ultimately what is best? Again, with I heard the call that we must do something and we must start somewhere. But unless we, again, identify the legitimate aim of what we intend to do, then starting somewhere could just be blowing in the wind. We could be doing absolutely nothing at the end of the day. So, some of the things that I was hoping to hear from the Attorney General, which I can still hear, I am sure, is in terms of convicted sexual offenders, the data that we have now, how many persons are return sexual offenders, or what is the rate of recidivism? I think that is important for us to know when deciding whether or not a register will work in terms of protection. We have to look at two things, right? The Minister of Labour, we have to look at a number of things, but the Minister of Labour said on a number of occasions that it is a deterrent. I heard no data to back up whether or not it is in fact a deterrent, and these statistics would be able to tell us whether or not, because the deterrent element is an important starting point in saying whether or not this act will protect anybody, because the deterrent element is the only protection arm that you can have here. Other than that, we won't be protecting anyone, but we will be saying that we are aggrieved as a society and we want extra punishment. Right. So we got the numbers in terms of cases reported versus convictions, but we really do need to know what is the rate of recidivism. And that brought me to one of the first studies that I got to, evaluating the effectiveness of the sexual offender registration and notification policies for reducing sexual violence against women. This study was done in 2010, and it was done by the Medical University of South Carolina. I picked this study to start with because of its specific aims. The aims of this study was to examine whether or not the South Carolina registration, and I started by saying that it was the most similar to what was proposed here, the South Carolina registration and notification policies, whether or not it has the intended effect of preventing first-time sexual offending, and to examine whether or not the registration and notification policies have the intended effect of reducing sexual recidivism for known sexual offenders. So those are two of the main points that I started with, and whether or not there were any unintended effects. The conclusions early on noted that there was a significant deterrent effect was noted after 1995. But post-1999, there was no significant decline post-1999, which is the year that South Carolina implemented its online sexual offenders registry. And that study was backed up by two others, which I would present to the Parliament, but I won't go into detail because it says the same thing, that a sexual offenders registry is useful, but the notification or the publication of that register had no direct impact on reducing anything after 1999. So the studies are telling us that the register is important, and we can all agree on the register. But whether or not the public needs access to the register is something that we really do need to think about. And I will go with the alternative arguments in terms of why people want a public register and what they see as the usefulness of the public register. But again, Attorney General, this is why things like the Joint Select Committee I think would have been helpful, because I am not an expert in the field. I did research over the last week, and I'm presenting that research here in my job as a parliamentarian. But there are experts in this field, and there are people who deal with this on a day-to-day basis. There are people who do this research, people who do this every day. And their knowledge, I think, is what we need to put into the decision-making on serious matters such as the such as the establishment of a sex offenders registry. The original aim of the registration laws was to provide law enforcement with a database, right? None of us will ever argue or argue against a database or data collection or understanding the criminal elements in our society. I see the value in that. And that the information from that database was intended to help monitor known sex offenders and assist in the investigation of new allegations. However, the community notification is the practice of releasing the registration information to citizens. And the intent of the public notification is to arm citizens with information to protect themselves and children from sexual predators. So that is the thinking behind it. But what actually happens, right? The sexual offender is now subject to public scrutiny or community scrutiny. So once you have, and Senator Truitt noted in her contribution, the kinds of offenses that are captured under here, and that would lead you to, would trigger, and Senator Amin also raised it, that would allow you to be placed on the register. And the question here becomes, what are the unintended effects of this kind of thing? And this, another study, this one by Hansen and Harris from 2004, noted that the vast majority of new sexual crimes were not committed by registered sex offenders, who by definition have prior offenses. I don't have that statistic for Trinidad and Tobago, but again, that is a useful statistic for us when making these decisions. Because if it is that in Trinidad and Tobago, the vast majority of sexual offenses crimes aren't committed by repeat offenders, then will the registry really be effective in protecting our citizens? They noted that a number of the registered sexual offenders, in facing community scrutiny, there was the sexual offender, but there was also the family of the sexual offender, whereby the children were stigmatized, the children of the offender were stigmatized, the family in and of itself faced a lot of difficulty. This is an unintended consequence. So while we are again thinking of punishment, and we are angry, and we are all agree that things like this should not be done, and our society needs to stamp out crimes of this nature, there are people involved who have not committed a crime, who would be affected by a public notification on our sexual offenders registry. And I just want for us to think about that as we go forward. When you look at whether or not you had to have a public register in Trinidad and Tobago, did we ever consider our culture in that space and how our society reacts to certain things? So I recall, if you just read the comments on social media underneath any story about pedophilia, about crimes, any crime against children, you read the comments, the vast majority of persons push for vigilante justice. They push for, the idea is that the system is too slow, that nobody's protecting our children, and that we want justice, and justice ought to be in our own hands, because it's too slow in the hands of the system. Now, contextualize that and take a public register, Mr. Vice President, and put it on the internet, a website. And you can go and find persons in your area who may have committed a crime, and and I'll get to these thresholds, right? you've committed a crime, you've been convicted of a crime, and you are living in my community. What is your reaction now? Is it that I now know I will protect my children from you? Or do we continue this idea of punishment? Do we continue this idea of these people ought to be punished fully by society? And that, again, divorcing myself and my emotions from this. Because instinctively, I have no desire to stand here and say we have to protect people who have committed these kinds of crimes. It is not the natural position that I would want to take. But that is not my job here today. And I fully endorse every single thing the Attorney General has said in terms of protection of children. And I would like to see, and anybody that's captured under this legislation, and I would like to see strong and robust legislation that would allow for the protection of children. I just respectfully don't think this is it. I think this makes us feel good about ourselves. It makes us feel like we have accomplished something when you can go online and see our register. It makes us feel as if we're doing something. But the data internationally is telling us that we aren't doing anything at all. And if we were better at data collection in Trinidad and Tobago, I'm sure, and if once our register is implemented, if we are very careful about the monitoring and evaluation and serious about saying whether or not the things that we are doing here are effective and working to an end goal, then I would say we would have done a good thing. Going to the memo that I'm sure we all received from the NGOs who I think legitimately felt like they aren't or haven't been adequately consulted. A number of the things itemized in terms of what is our public policy here, they are addressing the same concerns that I am attempting to address, but they are coming from it with a different data set and more specific drill downs into the areas that they would like, I think, to see changed within the bill. The question of competing rights comes up, and again, all of those things about the unintended consequences. But Mr. Vice President, I think one thing that they noted, which I think is very important here as well as we try to wrap our minds around what we intend to do. The section, well, 4.2 of their memo says the wishes of the child are not included and consistent with Article 15 of the UN Declaration of the Rights of the Child. Nor is there a mechanism for a child to report such offenses against their person other than through someone who may be the offender or have coercive power over them. See, these things are important because if we are talking about the protection of these children, all of these things have to be distilled and ensure that the legislation is robust enough to actually provide a protective measure. You know, the studies tell us, and Senator Choate started by talking about the spaces, the number of crimes that are captured and that would be captured under this legislation that would trigger you being on the register. And the study, one of the studies show, and this is on the other Harrison study, that showed that the register, the more offenses you capture under the register, the less effective it becomes. So there is there's a data set spanning 15 years in the United States that is telling us that the wider you try to make that net to get as many people on your registry, the less effective your register is. And so that's something we would want to think about. When you're looking at the register, are you separating the most heinous crimes from, because I think captured under here as well as indecent exposure, etc. How are we doing? Are we doing a tier system in terms of where they would be located under the online register, assuming we go forward with these things? And these details become extremely important when the data is showing us that a wide register, as would be implemented by Trinidad and Tobago if this legislation is passed, is not the most effective way to go about the registration of sexual offenders. I want to turn to some policy recommendations as it pertained, again, to the South Carolina model, which said to look at one of their main policy recommendations coming from studying how this has played out in the United States, because this is our first time here, so we do have to look to international models for an evaluation of the concept. And they said the basis of the sexual offender registry and notification requirements in general across the board really needs to be assessed, and especially the basis for the online notification notification requirements in particular. You see, the problem that struck me instinctively, which is this idea of an online public register, and for a number of other people, the data set is also telling us that that is the thing that, as it has been in practice in the United States for the last 20 years or so, is the problem that they are facing right now. The register being online is an issue because of the unintended consequences. The emphasis on registration compliance here as well. Another study, and like I said, I'll share the work cited with the Hansard record, showed that offenders who failed to register or failed to keep up with their registration requirements were no more likely to to reoffend. Thank you, Taharqa. They were no more likely than those who systematically kept up with their registration. So that's another thing we have to think about. We are reporting into the station. What is the impact of that, and how are we evaluating the concept as it goes forward? So the idea is that persons who are very good at reporting are just as likely to commit an offense again, statistically smaller, as persons who were not reporting as strictly, although the legislation does capture them in a different way. So that takes me to what the data is telling us and where we ought to be going. And then I go to section 44.1 of the amendments, which looks at that the Commissioner of Police shall, not later than 2 months before the discharge of a sex offender referred to in subsection 43, cause a designated officer to attend the prison or psychiatric hospital and then do a number of things. Good in principle. What will be the practice? The Child Protection Unit of the Trinidad and Tobago Police Service is required to have a total strength of 169 officers. Currently, the Child Protection Unit of the TTPS is operating with less than half of this mandated strength. So when we are legislating things, and we are saying this is the right way to do it, we're going to create this register. A police officer will be designated to go from collect the information, you put in the information, you meet it. And then in reality, right now, as we stand, and this is a simple fix, the Child Protection Unit of the TTPS is not well resourced, not well staffed, and is not given a high priority in terms of being able to effect the laws that we already have. So we add to this, and we are not giving them the resources. And this took me back, Mr. Vice President, to things like the anti-gang legislation and a number of other pieces of legislation where we're told, let's do this now. Let's start somewhere. Let us work together and pass the legislation, and you'll start to see the changes. We haven't seen any changes from a number of legislation that we have passed. The anti-gang is particularly important now because we were told, Mr. Vice President, we were told in this parliament that we know where the gang members are. We know we'll get them quickly. Everything will be off the board quick, running. And then this week, yesterday, CLOTs, gang violence, right? Right as we sit here and speak and we try to convince the population that we are passing all these bits and pieces of legislation that will help you will keep you safe, will keep your children safe. This is what we're being told today, that this legislation will keep our children safe. We were told that with the anti-gang legislation. We were told that with the DNA legislation. We were told that with so many pieces of legislation. And it just has not played out in that way. And so I am saying, Mr. Vice President, that as we stand here and you give, under Section 44, you give assignments to the Commissioner of Police and to the TTPS, why not in that same space make sure that our Trinidad and Tobago Police Service is well-resourced and capable of performing the duties in the manner that we would like to see, because all of these things have to work hand in hand. I went through the strength of the child protection unit, but they also face a number of difficulties in terms of effecting their duties as it stands. So I understand that the Commissioner of Police, then Stephen Williams, was consulted in the legislation, but I think we can go further, I think, and talk to the unit, right? Get reports from the unit that are mandated to deal with these kinds of crimes, and then they'll give us a much better picture in terms of what is happening on a day-to-day basis and how we can fix those problems. And is a national register or a public register the solution to the problems that they are facing? Because the same statistic that the Attorney General started with, that 1 out of 7 crimes are reported, that means majority of people are not going into the police stations. They are not reporting the crimes. This does not protect them, does not help them. It in no way fixes that situation. What are we then, as a society, saying? How are we going to help that particular problem? And those questions can be answered, I think, or at least thoughts can be put forward and the ideas can be ventilated in spaces like a joint select committee. How we go about protecting our most vulnerable citizens, I agree it ought to be on our high priority, and I completely agree that things ought to be done, but I also would like to say to the Attorney General that the list of organizations that said that they were not consulted or that they had no input and that they had not seen the legislation is very, very startling to me. Because is it that the expectation was that when you wrote to the minister in the office of the Prime Minister, who has responsibility for children and gender affairs, that that minister ought to have written to these institutions and sought their feedback? Because I really would like to know where the disconnect happened. How did this happen? Because as far as I am aware, if you're talking about sexual offenses, Rape Crisis Society should have been high up in the list in terms of persons to be consulted. So in listing the number of persons who were consulted, I really want to know where was the disconnect and how was this big gap of people just completely left out of the loop. And if it is that they were written to, and somewhere along the way the correspondence got lost, and therefore that is why we can say the legislation has been out for 8 months or whatever it was, and that we ought not to tolerate these kinds of things, well then yes, I would be on the side of the Attorney General and say, yeah, right? We can't wait for the last minute. But if it is that the legislation, and I think in the wrap-up, the Attorney General needs to be very clear to us, is it that these people were written to, and that we can see the correspondence, and they attempted to contact these organizations, and they were derelict in their duty, or is it that they were somehow left out of the loop? Because that, I think, is very startling to me. Now, we can talk about consultation. We can talk about widespread consultation in the face of a memo from interested parties who are saying not just that they have issues, but that they have recommendations and that they have ideas and that they want to share the ideas to make the legislation stronger and make the legislation better. Why would we leave them out? What is the thinking behind leaving out people like this? And I know the question becomes, how would the legislation change if the consultation was going to be opened up? And what is the difference between having this open and vibrant discussion across the floor, and that we could all list our ideas, and we can say what we would like to see differently. Well, in my respectful view, Mr. Vice President, our desire for speed, getting things done quickly, or checking boxes, because that's what I think is really happening here today, that a box will be checked. If we pass, thank you, Mr. Vice President. If we pass this legislation today, what we will hear at the next sitting or 5 sittings after that this government was responsible for the creation of our register, that's it. We'll hear that over and over. But what we will never hear is that the sexual offenders registry has, well, not that just that it's populated, but we have seen since the implementation, we never hear that, I can tell you, but we have seen since the implementation of X, the reduction of Y, and that it has achieved its legitimate aim. We never hear that. And that is my major problem as to what goes on here, you know. You bring the legislation, you tell us all these great things will happen. There's never any reporting, never any accountability that the legislation has achieved its legitimate aim. And we will always run into that problem if on the onset you cannot define the legitimate aim of the legislation. Because the legitimate aim of this legislation cannot be defined as protection, because from my examination of it, it is punitive. The idea behind this legislation is to say that we, Trinidad and Tobago, are angry. We hate all sex offenders, all blanket, and we want to put your name on the internet. And we want everybody to see you. We hold you up high as a social pariah, and that is what we're doing here today. And I respectfully do not believe that we would protect anybody. And our goal here as an opposition bench is the protection of children. And that's why you saw things like the Children's Act, and you saw things that the Children's Authority, you saw things, Mr. Vice President, that would say, let us as a society state that this is our priority and this is how we'll go about it. And with those few words, I thank you.
Yeah.
Senator Thompson-Ahye.
Thank you, Mr. Deputy President. I rise to speak on the Sexual Offences Amendment Act. Sexual offenses, as we know, is something very, very prevalent in this society. From where I sat, I had to listen to stories every week on the committee, and it really could make you very ill. And even before that, as a lawyer, I would listen to stories, and some of them were so horrendous. I remember a mother sitting before me, and she showed me the report from the doctor. This mother, who had been obeying the access order of the court and sending the child to the father every other weekend, the doctor said the anus and the vagina had become continuous. She reported to the police once, twice, and she would come back and say, he still has not been arrested. And the last time she came, she said, he is now in the United States. Nobody's looking for him. Before I went to a conference in Cardiff, I met with 2 clients, totally unknown to each other, and they both said to me, Mrs. Ahye, when my divorce finished, I would like you to help me to get counseling. One had been abused by her brother, the other one by her father. I went off to the conference and I heard a social worker say, children who have been abducted and been sexually abused recover very quickly. And I jumped up and I said, what? What? And that was a packed hall. And I said, that cannot be. And I repeated to him what had happened with the clients who, years before, these are women now in their early 40s, and they're asking for help because they have not recovered. And here was this man talking about children recovering very quickly. But unlike Trinidadians, he said to me, "Thank you for bringing this to my attention. I will never put that in my presentation again." And every time he met during the conference, he would say, "Thank you, thank you." In Trinidad, I was at a conference at a hotel of many names on a Saturday morning, and the United States psychologist or psychiatrist, many letters behind her name, said, "Children who are abused by their fathers hate their fathers." And I said, "What?" And the criminology department of UWI, the young lady there, said to me, "You know, you don't understand what you see. You must be careful. This little girl is telling me, and I'm talking about experience." And I had seen that from a background of the most horrendous cases of abuse that I've come across in Trinidad. The 16-year-old girl had been twice impregnated by the father, and the 4-year-old girl had been found with a venereal disease. At the end of the day, the court ordered that the file should go to the director of prosecution and the commissioner of police. That's what the judge ordered. I took the woman back to my office. Legal aid had put me to represent her. Before she left the court, she cursed the judge. She said the nuns and them don't mind their business, and she was really carrying on. And I pressed her, and she said, "What should I do?" And she broke down into tears. She had been abused too as a child. So you have this cycle of abuse. Years after, I'm reading a newspaper. Now, all the children were taken away. All the girl children were taken away and sent to various institutions. And I'm reading a newspaper, and something struck me as being a little familiar. So I went down to the legal aid office, and I said, "Can I see that file?" It was the same man. The same man where the court had ordered the file go to the commissioner of police and to the DPP's office. Nothing had been done about him. And he was now sexually abusing the boys. And I always remember the lawyer in the case saying, "My lord, pleading for this man. He is too old to go to prison. Do not give him a custodial sentence." That's what my colleague was saying. I was sitting in court one day, and we were all, about 6 of us at the bar table, and there was a matter of incest before the court. When we heard the address of the parties and the names, all the lawyers swiveled around to look to see who those persons were. Well appointed, and the area they were living, we were really, really surprised because we have certain assumptions. So the matter was adjourned. Coincidentally, on the next occasion when the matter came before the court, I was again in the Tanapuna Magistrates Court. And the young lady was not there. I looked and I saw the parties, well appointed, well dressed. Both of them could win beauty contests. Beautiful looking people, well dressed. And what was said is that she is not here, you know, because she went to Miami to study. And I looked at the prosecutor, I looked at the lawyer, and the next thing I heard, "Case dismissed." So when I see a provision in the legislation which talks about, Mr. Attorney General, about preventing people from testifying, I often wondered, I mean, was that the case here? Because I still carry in my mind's eye the face of that mother, the pain. And I said to myself, the police in Tanapuna would always call me, "Come into the witness room, help me, because there is this woman from Caroni, and she doesn't want to give evidence." And I would sit with her, and I would speak with her about her responsibilities and the child, and the woman would be crying. And of course, she's very poor, and she would say, "He said he wouldn't do it again." So she's conflicted. But they didn't call me in that case. They didn't ask for my assistance. and heaven knows what happened with that young, beautiful girl. We're discussing this legislation about sexual offenses in the shadow of Akil Chambers. And we know what happened with him. And we suspect why there's been no justice in this case. But, you know, we have many stakeholders. And we expect that the people would do their jobs. We expect that the police would do their job. We expect that all of the people who are supposed to be acting would do what is required of them. Now, before we reach the registry, we must have a conviction. Before we reach the conviction, we must have a prosecution. And before we reach the prosecution, we must have reporting. And I have said in this chamber before that I am not at all satisfied with who must report. On the last occasion I spoke about this matter, I brought examples of jurisdictions which have wider reporting requirements than we do. And I asked, please, could we do something about it? So since this is relevant to our purposes, what we're doing here, we're extending the categories of offenses, but not the categories of, in fact, who are the people who must report. And I'm asking through you, the Attorney General, look at Anguilla. I didn't mention Anguilla on the last occasion. Look at Cayman Islands. Look at Jamaica. I spoke about Barbados and Bahamas and the others on the last occasion. And you know, they mention things like member of the clergy. They speak also about the minister of religion, psychologists, and so on, probation officer, social worker, and so on. I think we need to zero in, because when you say any other person, people believe it's not me. They ain't talking about me. They're talking about somebody else. I'm not mentioned here. And I spoke in another place in this building about the reporting of things like pornography and so on. And I mentioned that reports are not coming out as they should. And when I speak from a position of knowledge. It's not old talk. And I would particularly like to see in this legislation psychologists. And I have a reason for saying so. And I said in another place, I saw it was reported in the newspaper yesterday, that some of the prestige schools that are aware of things that are happening within the schools are not reporting. They're not going to report. Now, I meant to begin by thanking the parliamentary staff. And I wanted to thank them for putting together the consolidation, the AG department. I've given them your praise. I'm sorry. But far be it from me not to give the Attorney General his pips. So I thank the responsible parties for the consolidation and the bill essential. You did the bill essential. I suppose you did the bill essentials as well. He can't take credit for that. All right. The only thing is it could have come earlier, because I have a confession. I have a confession. They say confession is good for the soul. I was coming here today when I heard that the Sexual Offences Amendment Act was coming before the Parliament, and I was planning for the AG. All right? And I was going to have my pound of flesh. I was going to be Shylock. And while I was thinking of being Shylock, I was also thinking that, you know, in the Merchant of Venice, they said that the quality of mercy is not strained, but I was not going to strain the quality of mercy because I was also thinking of Caesar. Forgive me for being a student of the classic. But he did say, John Cassius, as a lean and hungry look, some bushmen are dangerous. So I say maybe I would not get my pound of flesh. But then it was after midnight when I opened the attachment and I saw, or I didn't see, and I had to say like Shylock, it's not in the bill, it's not in the bill. So I said, no. You know what happened? He had a very hard day, you're too tired. Check it again in the morning. And in the morning I went back and I look again. And I say, that is how a balloon feels when you put a pin in it. You know, after all the work that I did, all the research, going back to when, we celebrated the 100th anniversary of the first juvenile court in Chicago, Illinois, and I sat down with the National Council for Children, and we all looked at all of these things, and I was armed and well prepared like Anthony, man. Give me a hand, Bassanio, I was about to say. And then what happened? The Attorney General, take it out of the bill. It no longer applied to minors. We waste my time. Because I was going to, you know what? And then I could no longer argue that point. So I must say thank you that it no longer applies to minors. They're not even using the word minors. So yes, you can hit the table for that. Thank you, because I really was very upset by that. Now, there's something called cherry picking. So we interfere with this and we don't interfere with that. And we interfere with this and we don't interfere with that. And quite recently, as a matter of fact, the report is dated on my birthday. This lady, whom we all know, Prime Minister Theresa May, says that she deeply regrets Britain's homophobic colonial legacy and doubles down on the UK commitment to LGBT rights. And I'm saying, but we are amending the Sexual Offences Act. So why we leaving buggery untouched?
If I may, the Honourable Mr. Justice Rampersad amended that law already in the Justice Jones decision. So the law as it stands, Section 13, has in fact been amended. And that is in the course of the courts right now. So it would have been infradig for me to amend that law whilst it has been amended and is under appeal only because of the need to clarify the law. And the further reason is that law in relation to buggery finds itself in 26 other laws. The umpteen laws across Trinidad and Tobago from the Immigration Act come down. So I didn't want to pull one thread whilst the law had to be settled. So the law has been amended pursuant to Justice Rampersad's decision in the Justice Jones matter, in the Jason Jones matter.
And that's not what you're appealing, right?
Yes. But I'll explain why.
All right. I'll wait for the wrap-up. Now, when you speak late in the day, you run the risk of other people taking your talks. So I had Senator Amin interfering with my baby, restorative justice. I will talk about that a while again. And then I had the other senator interfering with my business because the World Wide Web, I look and I got the Medical University of South Carolina report. So when she started to talk about it, I looked to see if it's still on the table. So that was my difficulty. But one, I thought it is a very useful report. And the fact is, the findings are very important. One of the things that came out of the report, and which should really guide the Attorney General and the public to understand that this is not going to be a panacea for all the ills of sexual offending. It does not solve the problems. It is, of course, a desirable thing because when your name is on a sex register, it is not just the legal consequences, but the social consequences. And in that report is referred to as unintended consequences. And you have people suffering, like the family of the offender and the children, because there are so many things that can happen as a result of your being on the register. So you have the situation of the housing, you have the stigmatization, you have the loss of job, the loss of friends, you have even the children in school, the way they will be, dealt with by the teacher, because teachers can be very unkind. And I say that because I was in the teaching profession. I suppose I still am at a different level. And sometimes what they do to children, really cannot be countenanced. Insofar as reintegration is concerned, there are things happening in other parts of the world. We have had a number of conferences, at least 6, and symposia dealing with restorative justice. But there is something holding us back. And actually, there was actually a conference that said restorative justice, what is holding us back? And I don't know what's holding us back. But it does have relevance for sexual offenders. And I speak here about COSA, Circles of Support and Accountability, where you have criminal justice volunteers who are creating supportive frameworks around sex offenders following their release. Because when they come out from prison and they have nowhere to go sometimes and no one to turn to, then the likelihood of the reoffending multiplies 1,000-fold. So you have representatives of the community, because it's the community that has to receive the offender back. And these people who are volunteers, they actually work with the offenders to assist them in various ways and to hold them accountable for the heinous crimes they have committed. And they are doing that on behalf of the wider society. You also have a program called the Restore Program, which facilitates survivors of sexual violence. And they work with selected individuals. Sex crimes are when they are committed by persons as their first offense, and the person's an adult. They work with these offenders to assist them to keep from reoffending. So they participate with them in programs. They have a chance to discuss with the offender and the victim what has happened, the harm that has been caused. Now, if the offender does not wish to participate, then the person can send a victim impact statement. At the end of the day, there's a redress agreement, including mandatory supervision. And whatever the victim desires, that is put forward at the conference. The offender must agree to undergo treatment and must complete that treatment within a year. If it is that he does not do so, then he will have to go back to the court and face prosecution. Another program is the victim offender panels, where you have a number of offenders who have committed sexual offenses, and they meet with various victims, but they do not meet with the victims of their offense. So you may have a number of women and a number of offenders, but not those who know one another. So what happens is that the women tell their stories, and the offenders listen. How has this impacted me? How have I been affected by what has been done? And sometimes hearing the women's stories for the first time, it has a tremendous impact on the offender. So those are things to be considered. Legislation is not all. And with the legislation that is being enacted, we must think about educating the police, educating the community, and putting in place a number of options so that at the end of the day, we do not have this recidivism. Because many times, what happens is that you come out of the prison, and because there is nowhere to turn, you go right back in. And what the studies are showing is that these registries, they work in the sense that the first-time offenders, aware of the implications of the registry, they desist. So there is desistance from offending, but those who are, in fact, are offenders, there is sometimes not much impact in preventing them from going back into their old ways. The level of risk has to be explored as well, and one of the things that one looks at is what kind of criminal activity went along with the act. Is it that this person was involved in other criminal activities? What is the propensity of the person? You look to see what kind of offense. And many times, what worries me though, with the first-time offender, who really is an aberration, when we put that person on the registry, is it the best thing to do? And I would like to refer to Restorative Justice, Contemporary Themes and Practice by Helen Bowen and Jim Considine. It's available in the Supreme Court Library. I brought in a number of them. It's written by these people from New Zealand who did the first training. I did first training with them. And there are a number of books that were purchased. So it tells the story of this offender who was a grandfather. One of the stories in here. And he abused his underage granddaughter. He was hitherto a very loving grandfather. So it created a lot of problems with his family. The wife, the mother of the child, the father, everybody was in turmoil. His elder son, they could not understand how such a loving grandfather can commit an act like that. So there was a conference put together. And what it turned out is that he had been looking at a pornographic movie. And I want to link this with the high rate of pornography that makes us famous in the world and say if that pornography is not linked with the number of sexual offenses that are committed in Trinidad and Tobago. What can we do about pornography? I know we talk about people's rights, but just imagine that if we can do something that would make sexual offenses fewer in the society, even if we have to curtail some people's rights, because sometimes people have to really be saved from themselves. Maybe, just maybe, curbing the pornography would help. And again, work for the police, because we know what happened when we had that very popular figure with all of the pornographic pictures and movies and so on, and he was allowed to leave the country, all right? We know the good churchman, what happened there, and the zoo man and whatever. So that we have had a history sometimes of not doing or dealing with what we need to deal with. And you know why? Because we believe only certain people should be in the prisons in our country. And certain people must not be in prison. But the poor, the disadvantaged, they flood our prisons. So we talk about, you have a role here for the Commissioner of Police. You have a role also for the Commissioner of Prisons. And if it is that the Commissioner of Prisons cannot at this point provide the DPP with the names of the persons in prison who would have served their sentences if they had been tried, then I don't hold up much hope. I'm very sorry. Because a lot of Commissioner of Police have been talking a lot of religion. They preach about God and God and God. but we had the year of mercy, and the Archbishop asked that we do something about the suffering in prison. I know you want to tell me about the new legislation is coming on stream? All right, I give way.
I'm very pleased to say that the past maximum sentence was done by the Commissioner of Prisons and by the judiciary. 7 people fell into that category only. And the reason is that multiple offenders were there for multiple offenses. So they may have passed maximum sentence for one aspect, but they had related crimes. So in keeping, I gave a solemn commitment to the Archbishop that I would conduct that exercise, and it was faithfully done, and I reported the issues and the results to Archbishop Harris in particular. So I assure you that that was done.
Hope springs eternal in the human breast. Do I have any more time? So, at the end of the day, I would just ask that everybody, all of us, play our part and do what we can. Because it is not only the children. Children don't remain children. There are many adults who are suffering and people who cannot function, and sometimes we do not understand the ripple effect. It has effect on the health. It has effect in the workplace. It has an effect in the home. So if we are to fix this thing, which is deep into the psyche of so many people in this society, we will go a long way in fixing the society. I met a young man who had a number of offenses. And the history was that as a young boy, very handsome young man, very personable, and he was abused as a child by his mother's friend. His mother did not believe him. He had a string of offenses. Who can you turn to if your mother cannot and will not support you because it is her friend? So we talk a lot about the girls, but there are lots of young boys who are suffering in schools. We also need to educate the medical personnel. We can't take it for granted that they know what to do. I remember a head of a department coming across, to the law school and saying, we want somebody to teach ethics. And I said, what about child rights? Why can't you educate the doctors in child rights? And he said to me, they have too many things on the timetable. I cannot put in child rights. I said, but I had sat with Professor Andrew Shepard at Hofstra University, and here were the doctors and the lawyers, and they were learning child rights. And it was such a powerful example of what we can do. Because sometimes there are doctors and psychiatrists who do not understand. And this morning I read a newspaper about a coach abusing a child. And I remember years ago, I was in a session presenting, and a woman came to me, and she said, anytime anybody tell me, Hazel, I have something to tell you, I know it's a burning thing, and I know it's going to keep me up tonight, and during the night. And she said, this child had been abused by the coach, and she was hysterical, so she needed another type of intervention. So we took her to someone who should know better, because that person was qualified to treat with this hysterical young girl. And what was the attitude? She can like if she never had sex before. So here is somebody in the medical field who is unable to understand that a child, a young girl having consensual sex is not in the same place as someone who has been abused by someone in a position of trust. So there is so much work in the country to be done. There is so much education that sometimes I grow weary, but I try. Thank you.
Senator Simonette.
Thank you, Mr. Vice President, for permitting me to contribute to this important amendment bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128. I listened to Senator Thompson-Ahye with deep interest as she shared with us her anecdotal experience with several citizens. To some extent, I feel that I'm connected to this initiative of the Attorney General in that, along with the member of the public sitting in the gallery earlier, Diana Mahabir-Wyatt, I undertook a task for which I had absolutely no training around 1995, 96. And that was lecturing on then Senator Wyatt's request, the Trinidad and Tobago Police Service, on what was then the the new or virgin, if I could call it that, Domestic Violence Act. This intervention in this act, in this bill, as we have heard today, is some 19 years overdue. The research on similar legislation in the world shows that sex offender registration legislation only emerges around the mid-early 1990s. So that this approach to criminal justice regulation and monitoring is not centuries old, but there is legitimate experience elsewhere that I will come to shortly in regard to how other jurisdictions have approached it, and indeed how other jurisdictions have battled with the very concerns expressed and rightly expressed by my learned friend Senator Choate in regard to having to balance our constitutional rights and privileges against intervention that reduces those rights and privileges, but dare I say, in this bill, in appropriate circumstances. So that the intervention, Mr. Vice President, is long overdue. And it is a long overdue intervention to strengthen law enforcement in the area of monitoring, tracking, and invigilating sex offenders, especially those sex offenders of serious sex offenses that have caused pain, suffering, and much harm to our women and to our children. I agree entirely with the Attorney General that the interventions are not such that require more protracted searching debate. And so I join with him in calling on the opposition bench to appreciate that the subject matter requires us to act, yes, responsibly, but we have had a long period of time to reflect on what we ought to be doing. The interventions in this bill are in the main practical and, I dare say, proportionate and balanced with regard to what sex offenders are rightfully entitled to do once they have complied with the reporting requirements in regard to the offenses that they've created. And I will engage in, just for the benefit of those listening, the public listening audience, in some comparisons to what other jurisdictions have been doing. Mr. Vice President, the National Registry that is being advocated in Part 3 of the bill will quite likely have the huge benefit of reducing recidivism and recidivistic conduct in this area of sexual violence. I think that the studies internationally more than support that sexual offenders, especially those of the more heinous crimes of sexual offense, are often repeat offenders. And in the jurisdictions that registration and notification have been practiced, it has been observed that the objective of recidivism has had some success. In our large country, I think that that success could well achieve better statistical performance than in larger countries. Mr. Vice President, my learned friend, I believe it was Senator Amin, thought that we should pause to obtain historical data on why the previous efforts at this task had not achieved success. And I think that with respect, on many occasions, statistical data is very useful and very helpful. But if we have had 19 years of inaction, what more statistic do you want than that?
That's a statistic itself.
That underscores, beyond doubt, that
Vice Chair, just to clarify, the point the Senator is referring to was not made by me.
sorry, did I say Amin? I do apologize. Senator Haynes. I do apologize, Senator Amin.
Distancing herself from her colleague.
The other criticism made, Mr. Vice President, is that the notification, that is, the website provisions of the bill, are merely intended to shame persons. And Mr. Vice President, I couldn't differ more with that interpretation of the objective of notification. It has been widely accepted in countries where notification has been deployed that notification has the significant public benefit of protecting the public by way of informing them as to the proximity or otherwise of sexual offenders who could be resident in their neighborhoods, attending educational institutions, or even attending the workplace. And one of the heart-rending contributions or references by Senator Thompson-Ahye was her reference to the tragedy of Akil Chambers. This area is not an area, and by that I mean this environment of abuse of children, of abuse of women, but especially I say the abuse of children is not a matter that affords us the flexibility of further prevarication and delay. And I really do urge those on the opposite benches, including the independent senators, to appreciate that the bill does indeed weigh proportionately the rights and the entitlements of a sex offender as against the rights and entitlement of victims, and the manner in which the monitoring, tracking, and notification is intended to be deployed. And why do I say that? You get on the register after you have been convicted of an offense. The offense that you're convicted of is not a minor offense. It is a serious offense. You are then remain on the register for a number of years so as to afford your conduct to be monitored and tracked by those with the duty to do that in protection of the public. Of course, the bill clearly indicates that the sex offender who has some compelling reason to justify being removed from the register can make an application so to do. So that therein lies one aspect of the proportionality of the bill that I mentioned earlier. And that applies also to the offender's right to cease to report if indeed he can justify same on an application. When one looks at the available material, the notification on public registers, and in this bill, Madam President, we have two aspects of notification. The first is the Commissioner of Police placing the registration information onto the website. And the second is placing the relevant information at the police station in the area where the sex offender resides. Publicly available information demonstrates that 29 countries have similar legislation to the legislative amendments being proposed in the bill. And in relation to notification on the website, Trinidad and Tobago will be no different to Canada, albeit Canada has an additional level of notification where the sex offender is convicted of an offense against a minor and considered to be high risk. We are no different to Guernsey, to Chile, to Jersey, and one locality in central India where the web development is being undertaken. In addition, I believe that the United Kingdom also provides for notification on the internet. No, I do correct myself. The United Kingdom does not provide for that. But it's done in South Korea. I do apologize. So that there is precedent amongst these countries for what we are pursuing here. And in relation to how such publication has been received by the Supreme Court of the United States, and I think it is important to appreciate this point, where one is considering the balancing of interest in this particular area of serious sex offenses, especially those offenses that are perpetrated against our women and children. So that the constitutionality of the web advertisement has been challenged up to the U.S. Supreme Court. The U.S. Supreme Court held in Connecticut Department of Public Safety and Doe in 2003 that the constitutionality of a Connecticut statute allowing sex offenders to be identified on an internet registry without first holding a hearing to determine their dangerousness to the community was upheld as, and not struck down as contrary to the Constitution. In another case, in an Alaska case, the Supreme Court ruled that registration and notification, and this particular case is very interesting for our circumstances here. When we consider the provisions on what I have crafted in my notes, the look-back provisions, that is, the requirement of past offenders to register that is provided, I believe, at clause number yes, it's 37 of the of Part 3, where section 37 stipulates that a sex offender who is a national of Trinidad and Tobago or a resident who is convicted of a registrable offense by a court within or outside Trinidad and Tobago on or after 25th September 2000 is required to register. So that would be someone who committed an offense before these provisions came into force. And this is what the American Supreme Court had to say in an Alaska case on similar facts. In the Alaska case of Smith v. Doe, the court ruled that registration and notification of offenders sentenced before the law went into effect did not constitute ex post facto punishment. The Association for the Treatment of Sexual Abusers has developed a set of recommendations that they believed will facilitate that the original goal of registration and notification continues to enhance community safety. So that I think that we are in reasonably good company when drawing the provisions here against the likelihood of there being either constitutional infringement or an imbalance with regard to treating with the rights and privileges of a convicted sex offender. And dare I say, Madam President, that we tend as lawyers, some of us, to have an oversensitivity to protecting Section 4 and 5 rights under our Constitution. That is, the right to freedom of movement, privacy, and so on. Ordinarily, were there to be infringements of those rights without justification, the sensitivity is well placed. But I think we have to be careful in this particular area of not squandering the opportunity to start, as the Attorney General has indicated, a process that leads us to avert ever having to experience again the likes of the tragedy of Akil Chambers. So I urge members to read the provisions of the amendments very carefully before rushing or even getting there slowly to a judgment position that we are in some way in danger of infringing rights and privileges. Bearing in mind that the situation regarding the statistics that have been shared with us certainly demonstrate that there is more a disregard for law, a disregard for order, and an intent to continue in that vein that we require as legislators to take very seriously, if at all we intend to arrest the serious decline of our society and the hindrance of development of the common good as something that we all aspire to. Madam President, the provisions of these amendments also require a great deal of administrative input from the Trinidad and Tobago Police Service, as well as from the prison service. And no doubt, we take heed of the need to ensure that those divisions of our criminal justice oversight are well provisioned to deploy the tasks that are placed before them. The other concern that I would indicate we ought also to be alert to is that we should bear in mind the concerns expressed, I believe, by Senator Ahye and by Senator Choate, that rehabilitation and counseling should be elements that we move towards as being part of the environment of treating with victims as well as offenders. Without dismissing it as being irrelevant, we also need to tread carefully as to what modern experiences we consider may or may not be appropriate to our society. And I think that in the area of sexual offenses, asking for exploration into victor-offender reconciliation is a little bit wishful in our small society. Madam President, I believe that the bill provides very adequately the type of information and the category of information that is intended to be displayed or to be accessible by the public on the internet and at police stations. In addition, I think that the penalties for non-compliance, which sound in both financial as well as incarceration penalties, are sound in an attempt to dissuade from either reoffending or offending. And in each case of the requirements to report, the failures to do so carry the appropriate consequences. Again, in the balance that I think the bill achieves, an offender who is required to register has an opportunity to make timely submission of any changes in his circumstances or any changes in the information that he has previously submitted on registration. In relation to, and that is in relation to both changes in circumstances if he requires to move residence, as well as in terms of his anticipated movements out of the country. Again, the time period is shortened where an offender, a registered offender, can show that because of some emergency, whether medical, family, or otherwise, his requirement to travel had not permitted him to report in the longer time period, and he's permitted to report such circumstances, I believe, 2 days before he requires to travel. Again, the proportionality of accommodating and ameliorating the draconian effect of having to give long periods of notice with regard to movements abroad. Again, there was a strong opposition to the provision for notification in a passport. I myself had thought that provision didn't fully, wasn't set out, and that it was a provision requiring the Chief Immigration Officer to keep a record. But that provision of notification in a passport applies only to the most heinous offender, that being a child offender. Madam President, could you indicate how much time I have left?
You have until 6:54.
6:54. 10 minutes. Madam President, so in treating with this area, I would urge that we not consider a requirement for further penetrating discussion in the form of Joint Select Committee appointment, that we appreciate that an intervention is long overdue and urgently required, and that we join in a bipartisan effort, which is indicated by all speakers thus far on the other side, to ensure that this item of legislation is operationalized, and more importantly, the subject of a communications effort that brings the provisions to the attention of the general public, including the very important consequences regarding contravention of the provisions. So having said that, Madam President, I wish to urge my colleagues to support this bill and to support the approach to its speedy passage that we on this side contend for. And I thank you.
Senator Obika.
Thank you very much, Madam President. As I rise to contribute to the Sexual Offences Amendment Bill 2019. A lot of this debate, Madam President, is centered around the creation of or operationalization of a sexual offenders register. And as I begin, I would like to quote from the Model Guidelines for Sexual Offense Cases in the Caribbean Region, publication of the Judicial Reform and Institutional Strengthening Jurist Project in the Caribbean. And I want to quote from the foreword by the Right Honorable Sir Dennis Byron, President of the Caribbean Court of Justice, dated 8th of August 2017. And I quote, "Although progress has been made in the Caribbean region in promoting gender equality, there are still many aspects which remain unresolved, chief among these being sexual violence amongst women, young girls, and boys. The region experiences high levels of sexual and domestic violence, which are often underreported and ineffectively dealt with by the justice system." I want to go to a second part of that, which states, I quote, "Greater effort is therefore needed on national and regional levels that will markedly improve the capacity of courts to handle these types of cases efficiently and justly, improve treatment, support, and protection of survivors and witnesses in the criminal process, and ensure that those who have suffered from sexual or domestic abuse are able to give clear and effective evidence in court." Now, Madam President, that statement speaks to the efficiency and effectiveness of our criminal justice system in dealing in particular with sexual offenses. And sadly, much mention was made of Akil Chambers. And it begs the question if really and truly this legislation on its own would have really resulted in a different outcome. And that question is left to be answered. Because if one were to take the foreword, and I can't read the entire foreword, but if one were to take those two excerpts from the foreword of the Right Honorable Sir Dennis Byron, no less a person than the President of the Caribbean Court of Justice, we would recognize that really and truly the problem is not necessarily only with legislation, but with the wheels of the criminal justice system, where it administers, in particular, sexual offenses. And one point the Honorable President stated, Madam President, is that speedy adjudication of cases and reduction of case backlogs over time is one desire that they hope that the adoption of these guidelines, which would have been piloted just over a year ago, would result in. Now, I want to turn to something regarding the register, all right? Because a lot of persons have made commentary on it. And this is in particular with regards to the publication of the register and availability of it online. So in a sense, to all humanity. And this very document, which I cited, states on page 42, and I quote, "In some jurisdictions, there are provisions for a sexual offenders register in the sexual offences legislation. The legislation may designate that convicted persons in all or specific offenses will be registered. It is recommended that a sexual offense register should contain primarily convictions of serious sexual offenses and make a further provision for application to be made by the DPP in special circumstances for non-serious sexual offenses where the public interest would require that due to prevalence of crime or for serial offenders." And the second point, which is the more salient point pertinent to this argument, is that I quote, "The main purpose of a sexual offenders register is to help police services prevent and investigate sex crimes by giving police agencies access to a data bank containing confidential personal information about convicted sex offenders, particularly their residences, to track and inhibit sex offenses." Madam President, if we are to rely on this project, which one would expect is inclusive of our Caribbean civilization's focus in terms of dealing with sexual offending, one would expect that we would have followed or mirrored is a stronger term, but at least followed these guidelines with respect to the accessibility of the information in the sexual offenders register. And just to divert a bit, one of the groups that submitted their concerns in terms of the consultation, the request for this matter to be ventilated at the Joint Select Committee indicated possibly to mitigate against sexual offenders reoffending, to mitigate against recidivism, to allow access to special interest groups who may have charge of our children, for example, schools and libraries and so on. So, which is really an expansion beyond the police. I want to suggest, Madam President, an alternative. Before one seeks employment, the trend is today that you must submit a police certificate of good character. Whilst I am not familiar with what it has if you have a record, because I'm not one who has one, a suggestion can be that if someone is a sexual offender, when you request a police certificate of character, it may indicate separately from other offenses if you are a sexual offender on such a certificate, so that the institution with whom you are seeking employment can identify that particular example of offense and determine if they want you in the institution or not. So for instance, if you are employing a security guard at a secondary or primary school or a daycare, or you're employing someone at a daycare or secondary school and so on, you can decide, because you'll have this specific reference. So what it does, it protects the concerns that persons from the NGOs and the special interest groups have with the information being available to the public and precipitating vigilante justice. So in essence, the information is accessible, but through the medium of the police certificate of good character, which is pervading our society today. So that is the suggestion. And I want to stand on another limb from the very document, the Model Guidelines for Sexual Offense Cases in the Caribbean Region, where they cite a best practice sexual offenses registry for Canada. It's a short paragraph, and I wish to quote, and I quote, "The Protecting Victims for Sex Offenders Act, SC 2010, now allows for automatic inclusion of convicted offenders in the registry, mandatory DNA sampling of sex offenders, registration of sex offenders convicted abroad, notifications to other police. The registry is not accessible by the public and is restricted to police officers, allowing all police services to search the registry and can use the information to notify other police when sex offenders are traveling to their area. Offenders convicted of more than one sexual offense remain on the register for life." Just want to stop at that point and just make reference that remaining on the register for life, because the register is only accessible to the police service, means it cures the issue that the concern that persons may have that someone may appear on the register for a crime as serious as rape and then no longer be on the register at some point in the future once they seek recourse of the courts. So that the fact that the register is only accessible by certain mechanisms, you can leave persons on the register for life if they are if they have reoffended more than once, and that then gives the opportunity for better tracking. And I continue to quote, "Offenders are required to notify police of any change in address, work vehicle they own or use. The registry also includes information about the offender's method of operating to assist other police officers in investigating crime." Now, because, and I end quote, because the register is accessible only by this method, it allows you to capture much more information. And that is and because I'm standing on the best practice as proposed or recommended, which is a stronger term, by the study done by the Caribbean Court of Justice, I believe that the Attorney General would see the wisdom in that suggestion. So I want to just divert to special interest groups, and this is really with respect to researchers, Madam President. And I quote from an article in the Trinidad Guardian dated Thursday, 26 April 2018 by Camille Clark, and it's titled, "Prof. Reddock at a symposium on abuse, child sex offenders going unpunished. And there are 2 points I want to just highlight from it. And the seminar was on Break the Silence, BTS, Educators and Child Sexual Abuse Symposium at the School of Education Auditorium, UWI St. Augustine campus. And Madam President, one has to collect oneself very well to contribute to this debate, because it's a very emotive debate, and we don't want emotions to cloud the contributions that we make, because it affects everyone. And I just want to say that the contribution of the Honorable Minister of Labour was very moving in that regard. So I'm trying to control myself.
Should get a heart attack today.
Yes. No, it was very moving. So, Madam President, Reddock said that the research was to understand how the act was rationalized and justified. And she said here, I quote, "I believe there's been a consistent problem of underreporting, and I believe that this is still the case." So I want to turn to my notes where I made a comment there regarding recidivism. And I want to turn to section 40 of this bill, part 4. All right? And this section basically speaks to, I need to read the notes to remind myself. The section states that information in relation to a sex offender referred to in section 37A shall not be published on the website referred to in subsection 1. That is a sex offender who has completed a sentence before this part. Right, and this masks 2 issues. All right. One is the issue of recidivism in the Caribbean, and the other has to do with the detection rate challenge. So the elusiveness of tracking reoffenders or offenders, and then the challenge of detection rate. So the fact that someone has not been convicted, Madam President, so one has been convicted, they have been sentenced, and they have fulfilled their sentence as the justice system demands. And they are now off the register. They being off the register can be deemed to be good justice if we have a very high and satisfactorily high detection rate. But if one were to depend on the submission of Professor Rhoda Reddock, and the Honorable Attorney General made mention of a 1 in 7 in terms of detection or conviction, I stand to be corrected on the actual terminology. So if in essence, that's the challenge that we have in terms of detection and follow through the justice system, one can't rely on the fact that someone has not been reconvicted to really be sure that they have not reoffended. And that is the problem of recidivism in the Caribbean. Now, another point is the gaps in the justice chain in the region for sexual offenses. And the very document that I quoted from, on page 10, they point to some gaps, 6 gaps. And because I couldn't commit to memory, I wish to quote it. So I quote, "Poor investigative and evidence-gathering procedures by the police." And I wish to elaborate, only to say that Senator Haynes did make mention of some of these issues, so I don't need to go further on that. The second point, inordinate delays in completion of cases. And I remind you, Madam President, of when I began, I indicated that the President of the Caribbean Court of Justice pointed to the issue that the justice system, in terms of efficiency, must be a key cornerstone in handling or bringing to rest the issue of sexual offenses in the Caribbean. So inordinate delays is a big problem. The third point is undervaluing of sexual offense cases in relation to the public interest. Sorry?
I have to interrupt you here because I need you to remember what previous speakers have already dealt with in respect of the bill, But I also need you to remember the bill that is before us. So it is not everything on sexual offences that will be relevant to the bill. It is to the debate that will be relevant now. You need to speak to the bill, to the particular clauses in the bill, what the bill is seeking to do. Okay?
Thank you very much, Madam President. I wish I could have submitted it, but okay, I will go on to section 43B and 44. And the issue I want to bring to bear here is the impact on the innocents in this whole thing. And I haven't heard anyone mention on that. So I'll explain what I mean. As reference to the importance of psychiatric treatment for sex offenders. And I want to state, Madam President, that there are persons who are connected to sexual offenders who themselves are innocent. A very simple example that I'm sure no one will argue with is where someone is a sexual offender. They have found themselves on the registry, publicly available via the internet, and they have children. And these children can now be labeled the child of a rapist.
That point has been made by several different speakers. So you need to make some new points because I have to caution you on tedious repetition. Okay?
Thank you very much, Madam President. So I proceed. I would go on to children of incest, but I'm not sure if I will be allowed. So I'll go on to offense of providing false information. Now, there are instances where I've seen personally persons venture false information through no fault of their own, simply because they may not be in a position to understand the implication, the questions and the line of questioning. For example, and if I were to bear this example, there was one example of an individual being placed before a magistrate and being asked the question if he has any prior convictions. And of course, he gave a defiant no, to which the prosecuting officer, police officer, was defiant. He said, no, that can't be true. So the magistrate rephrased his question and asked, you ever make a jail? And of course, he gave a long list of prior offenses. So this may sound humorous. And this may sound humorous, Madam President, but it meant that the individual simply did not understand the question. So I would hope that in the instances where this may occur, there may be some level of explanation for persons involved. It may be a simple point, but it's a point I wanted to make nevertheless. Now, Madam President, I want to go on to the guidelines for offenders' rehabilitation and management. Before I go on to that, there's a point I wanted to bring to bear regarding case management in the magistrate's court. And again, once more, it's from the very document that I cited at the beginning, Model Guidelines for Sexual Offense Cases in the Caribbean Region. And I would seek your permission because this section would take some doing in terms of reading. It's 8 points. Okay, thank you very much. And you can guide me as you always do, which I'm grateful for. Point 1, though most of the case management process ought to be done at the first hearing, where directions are given for disclosure and other matters, there may be additional hearings to give further directions to prepare for trial. 2, basically it states what should happen. And we must juxtapose this with what we have in the bill and what we know is the situation before us in the current system. 2, typically the case may be called up at least 3 times before the actual date for trial is set. 3, the court must minimize the number of hearings in sexual offense cases by ensuring appropriate directions are given and that timelines are adhered to. Number 4, in some cases, sexual offenses in the magistrate's court will involve child complainants. I will stop that point there and continue. Point 5, one of the main issues that must be considered by the magistrate court as part of the case management hearings is whether there are ongoing analogous applications pertaining to the circumstances of the case in the family court.
So, Senator Obika, if we were debating a new Sexual Offences Act, and we're talking about all the different offences under the Sexual Offences Act, what you are saying would be extremely relevant. We are dealing with an amendment bill to certain clauses of the Sexual Offences Act, not all. And therefore, that's what I'm trying to get you to say. Whatever you are saying, you need to tie it in to what we are dealing with. And what you're giving me is a lot of information, interesting information, but you're veering off of the bill, okay?
Thank you very much, Madam President. I was seeking to address issues raised in Schedule 1, registrable offences. At this point, I want to end my contribution. And I wish to thank you for the opportunity to contribute. Thank you very much.
Senator Vieira.
Thank you, Madam President. Because my contribution may run the risk of being criticized as being soft on criminals and that I'm a bleeding heart, let me state from the outset that I acknowledge the need for and I support all effective measures that will address the epidemic of sex abuse in our beloved nation. For those, especially children, who have been sexually abused, life loses value. Sex crimes are horrific. They cause physical, psychological, emotional damage to the victim and to the victim's family. And this is damage that can last a lifetime. So we all share the goal of wanting to protect citizens from sex abuse. Let me also say that there's much that's good in this legislation. It's well intended. I very much like clause 35, where you have the accused medically examined to see if he's suffering from any sexually transmitted infections. I like the Romeo and Juliet provisions, where child offenders will not be put on the register. Clauses 35B and 36, where convicted persons must pay compensation to those they have violated and hurt. Again, all very admirable. And I'd like to see it maybe extended to other bits of legislation. But in the main, my concerns really center on the National Sex Offender Registry. Whether the registry will do much good in terms of preventing sex crimes. Whether the registry will ostracize offenders, turning them into social lepers and putting them at risk. Concerns that the legislation will have little, if any, impact on crimes of incest, where sex crimes are perpetrated by teachers, coaches, clergymen, and people known to the victim. Concerns that the legislation will have little or no impact on the pedophiles who operate on the dark net using webcam sex. Concerns of a constitutional nature, privacy, freedom of movement, discrimination, and the right against self-incrimination. I am one of those lawyers who tends to be sensitive about these kinds of things because they are, in fact, fundamental rights. And I also have concerns about how the legislation might impact on homosexual relationships between consenting adults, given that buggery is still a criminal offense. I agree with the Honorable Attorney General that there is no simple solution, no one panacea for the devastating problem of sex abuse. But I am concerned that the National Sex Registry may give rise to a false sense of security without providing real solutions. In my respectful view, and for the reasons that I will give the National Sex Offender Registry and related policies are fundamentally flawed in that they do nothing to support prevention. They're not a deterrent. They do little or nothing for people who have survived sexual abuse. They will put offenders at risk of technical violations, failing to report, failing to inform of a change of address. As Senator Obika has said, when you're dealing with some of these guys and they may not even understand what they're doing, they will be continually offending and staying within the criminal legal system. And I don't know if that's a good thing. I think the thinking behind the registry is if you commit a sex-related crime, you go on the registry. Now, besides the obvious fact that the registry places a burden in terms of monitoring as well as costs and legal consequences, as Senator Haynes properly pointed out, in countries where there are sex offender registries, there's been no demonstrable effect that they have actually reduced sexual reoffenses. Instead, there are reported instances of harassment, ostracism, and even violence against former offenders. And remember, these are persons who have finished their sentences. And what they really need is a place to live, to participate in family life, and to get meaningful employment. I remember when I used to practice at the criminal bar, often getting calls from guys who had come out of prison. Can't get work anywhere. Could you help them find somewhere? And I would call all the guys that maybe had estates in the country and say, well, you know, give the guy a little job. He could be a watchman. He could be a caretaker. Nobody would touch them. Nobody would touch them. And so if you find yourself on a sex registry, well, you're anathema, right? You are just not going to get anywhere to live, anywhere to work. And what is the effect of that? It may very well drive you underground, alienate you further, and lead you back to a life of crime, which is not really what is the intended purpose of this. And as Senator Thompson-Ahye talks, rehabilitation, that is one of the major goals of the criminal system. There is also this assumption that once you're a sex offender, you're always a sex offender. But research has indicated that that assumption is highly questionable, if not downright false. Indeed, studies have shown that sex offenders, once caught, have one of the lowest rates of recidivism of any class of criminals. Studies show that treatment can be effective for those who commit sex crimes. So unsurprisingly, Human Rights Watch recommends, and again, this is what Senator Obika talked about, that registration requirements should be limited to those offenders who have been assessed as posing a real risk of committing another serious sexual offense. Now, that being said, we should be mindful that onerous restrictions and counterproductive measures, as I said, may only serve to isolate the offenders and push them underground, when what they really need is family support, treatment, supervision. And so the focus should be on reducing recidivism, not further punishing or having continuing punishment. In fact, many jurisdictions that have sex registries are now rethinking the efficacy of those registries. So it's something to look at for sure. Having your name on the registry is akin to being, as I said, a modern leper and an outcast. And so I think this legislation may actually impede offender rehabilitation. All right, I recognize that there are many who will say, he's a beast, he deserves no less, I feel no sympathy for him. But does that resolve the problem? Will that prevent crimes perpetrated by relatives, by caregivers, by people known to the victim, and on the internet? Because the vast majority of sex offenses are committed by trusted family members, by friends, and people known to the victim. And these crimes go unreported because of the manipulation of the victims. Family members, the offenders saying, well, you can't do that. If you go, it's going to cause real shame and disgrace on the family. You know, you want your family to be in trouble with the law. So these offenders never really get into the criminal justice system. And as a result, the idea of a sex registry may give the public a false sense of security. Now, so far I've been talking about those who have already been caught and convicted. All well and good. But as I say, will it prevent further sexual abuse? Let's consider now the issue of child pornography and cyber sex. A $1 billion industry across the globe. First point, we like to think that pedophiles are, somebody used the word aberration. They're an aberration. They're relatively rare. Well, that's not so at all. According to some studies, it's much more common than you might think. Apparently, 1% of men are pedophiles. That is, attracted to prepubescent children. Second point, our children are not just at risk by those who are convicted. This global demand for child porn, with sites and forums all over the world, especially in poor and developing countries, and we've had lots of reports about how big the industry is in Trinidad, for relentless users sharing child porn. This legislation does not address child porn and cybersex. We're talking about heavily encrypted sites where child porn is traded. Big money is involved. So much so that in many instances, the children are treated as commodities by their very own parents. There's a word called pedomom. And pedodads who abuse their own children for webcam sex. And so this legislation does little or nothing to address the pedophiles who operate on the dark net. And just as a matter of interest, on Netflix, there is a documentary called The Dark Net, and it treats with some of these issues. Let's look at incest. Like Senator Thompson-Ahye, I have also had experience treating with incest cases in the court. It poses many, many challenges, right? Often, the offender was himself or herself a victim. Incest just doesn't happen so. Usually, it's been going on for generations. It's been cyclical, right? The victims and the other family members don't want to testify. They don't want to testify against loved ones. They don't want their brother, their grandfather, their stepfather, their father to go to jail. And if they go to jail, how do they live? That's a very real concern because more often than not, the offender is the main breadwinner. So it's a very, very difficult situation. And even well-intentioned lawyers trying to help because we bring our moral values to the thing, end up looking as though we are the ones that are trying to hurt the family and separate loved ones from each other. Whether it's incest or pedophilia, what I think is fundamental is the need for treatment. Laws like this, sex registries, and even harsher penalties will not stop these offenders. These people cannot control what they are. And we have to help them control what they do. Incest, oftentimes the rationalization is, look, he's just showing love. And this has always been how it's been done in this family. And in pedophilia, I'm sure Senator Dayal Singh will tell you, there's a phenomenon known as disassociation, where the offender, even where he recognizes that what he's doing is wrong, is able to separate himself from what he's doing, and so ignore social norms and the fear of law and all of these different things. So, should this legislation go to a select or a joint select committee, I would urge a focus on how to prevent crimes by new offenders. Sexual abuse and child molestation are real problems that need real solutions. We need to turn our attention and resources to ways that are effective. I would respectfully suggest sex education in schools, the need to develop and fund public educational programs that teach about the effects of sex abuse and the importance of reporting abuse so that it can be stopped. The need to provide mental health treatment for both victims and offenders. Convicted offenders should not be allowed to use the internet. And just as convicted offenders are required to provide samples, I would suggest that they should also be required to undergo counseling and treatment. We need measures that will address the epidemic of sex abuse in ways that work. The challenge is how to accomplish this in an effective and meaningful way. Madam President, I thank you.
Leader of Government Business.
Thank you, Madam President. Madam President, I now beg to move that the Senate do now adjourn to Tuesday, the 12th of February, 2019, at 1:30 p.m. At that point, at that sitting, we'll continue the debate on the sexual offences bill.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Senator Mark.
Thank you, Madam President. Madam President, the issue confronting members of the protective services and the need for appropriate programs to assist them is extremely important and if not urgent. Madam President, the truth is that policing, as one of the elements involving the protective services, is a very stressful job. I think members of the protective services, whether they're in the Defense Force or in the police service or in the fire service, they undergo extreme stress in their responsibilities and carrying out their duties. This evening, I would like to look at the plight of police officers who are engaged in this particular area. Madam President, I think that the time has come for the government to give consideration to the establishment of a special unit that would be able to monitor and to pick up issues without waiting for an admission. Many officers in the service, like any other human being, would be experiencing serious challenges. Maybe some of them are going through a divorce or even a separation. Maybe their children are giving them trouble or problems. Or they may be having problems in their communities. And there's need for intervention and there's need for assessments, Madam President. Madam President, because of the absence of a particular unit within, let's say, the police service to conduct what I would like to describe as psychometric, behavioral, and even psychiatric analysis of officers who may be undergoing stress or dealing with frustrations. You end up, Madam President, with these officers either taking their lives, taking their family lives, and you have a tendency in this country to deal with the situation after it develops, Madam President, and there's no proactive measures being employed. And therefore, it is incumbent upon us and the government in particular to pay attention to the plight of police officers and members of the protective services who, as I said, would be undergoing mental stress, frustration, and other emotional and psychological disturbances. Madam President, if you look at the police service as an example, you would realize that over the last few years, many police officers have taken their lives through suicide, as the case may be. And many of them, Madam President, whatever challenges they were going through or experiencing, somehow they were not, those symptoms were not detected early. And therefore, I think it is incumbent upon the government to pay attention to this development, Madam President. Madam President, we have over 7,000 police officers in the service. It is my understanding, and I need to be corrected by the government, that there's only one psychiatrist available to 7,000 police officers. And my information, Madam President, is that we have 2 doctors, one in Port of Spain and one in San Fernando. And there is some arrangement in Tobago. And doctors in Port of Spain or the doctor in Port of Spain can only see a maximum of 25 police officers on a daily basis. In the South, I understand the challenge is even more grave, whereas in Tobago, it is done twice a week. And all of these are doctors, Madam President, they are attached to the Ministry of Health. So, Madam President, I think that there is a need, because remember, police officers bear arms. And if police officers are under mental stress and emotional strain and are experiencing psychological problems, you could understand having these officers with weapons. They can pose a danger not only to themselves, but to members of the public. And that is why I believe that the government is not doing enough in investing resources in the police service, in the Army or the Defense Force, and other arms of the protective services. Madam President, I understand in the Ministry of Education, there's something called an Employee Assistance Program. But that program apparently has not really been properly developed as we speak at the level of the police service. We understand that moves are afoot to have a properly established and developed EAP program or arrangement in the police service. Madam President, would you believe that even the availability of pharmaceutical products is in short supply in the police service in terms of when they need to get medical attention from this doctor in Port of Spain or doctor in San Fernando, or the arrangement that they may have in Tobago? Madam President, I believe that the time has come for us to have an arrangement where there is almost like a compulsory assessment of police officers, right, on a regular basis. Maybe, Madam President, every 5 years, there ought to be some compulsory assessment of police officers, members of the Defense Force, and other members of the protective services, so that you can detect, Madam President, and discern, based on the professional examination of these officers, their mental state, whether we have psychiatrists, whether we have psychologists. Madam President, we would be able to make the assessment of what is taking place. And therefore, I raise this matter, Madam President, for the government's consideration, because that is a major issue affecting the police and the protective services in Trinidad and Tobago. The absence of a well-defined, proper employees protective arrangement. Thank you very much, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, I thank Senator Mark for his motion. And let me say right away, understanding the Senator's deep concern, there is an EAP program in the Trinidad and Tobago Police Service. There is, in each division of the Ministry of National Security, there are specialized arrangements to deal with the employees in each area. And I know Senator Mark appreciates details, and I would now provide all the details. First, in relation to the Trinidad and Tobago Police Service, Madam President, the TTPS is cognizant of the fact, as Senator Mark has rightly pointed out, that there are times when personal problems such as alcohol or drug abuse or dependence, mental disorders or other psychosocial disorders may affect an employee's well-being and job performance. To demonstrate its commitment in promoting the health, safety, and welfare of all individuals employed in the organization, the TTPS has in place an Employee Assistance Program, EAP. Madam President, Senator Mark will be happy to know that the EAP is available to all police officers, special reserve police officers, public officers, permanent and regular daily rated employees, and contract employees, and their immediate dependents. The EAP includes clinical services such as assessment and referral, short-term and long-term problem resolution, case management, and follow-up. In addition, there's an EAP for the promotion and education of the employees on all matters relating to their health, welfare, and safety. Madam President, accessing these EAP services is available through a supervisor or peer counselor who may suggest that an employee attend the EAP, or the employee can do a self-referral. The TTPS, Madam President, also has peer counseling, which is a proactive measure for peer-to-peer support. And the TTPS has a 45-hour peer counseling course for police officers and recruits. In relation to the Trinidad and Tobago Defense Force, Madam President, the Trinidad and Tobago Defense Force Welfare Department Care and Assistance for Military Personnel, called CAMP, was established in 1981 to deliver confidential social services in response to the needs of individuals and families within the Defense Force. The support services provided to service personnel include management of depression and other mental illnesses, counseling through internal counselors trained in general counseling, peer counseling, marriage and social support, and external counseling through service providers such as mental health and wellness centers and contracted professional counseling services providers. The Defense Force also have programs for the prevention of depression and other mental illnesses through financial guidance, health insurance, outreach programs, a program called BOSS, Better Opportunities for Single Serving Persons, and finally, career guidance. Further, Madam President, the TTDF has special units, including a Retirees Affairs Support Unit, a Family Support Unit, a Chaplaincy Unit, Addictions Support Unit, the Social Worker Counselors Unit. The Defense Force offers a series of seminars and workshops aimed at addressing issues like depression and mental illnesses. The Defense Force has mental health seminars, a program called Applied Suicide Intervention Skills, HIV sensitization awareness workshops, critical incident stress management sensitization workshops, and the chaplaincy certification program aimed at increasing the number of Defense Force chaplains. I'm sure you like that one, Senator Mark. In relation to the Trinidad and Tobago Prison Service, Madam President, the Trinidad and Tobago Prison Service has a prison psychologist who treats with matters concerning mental illness in the prison service. If an officer requires further attention, the psychologist refers the officer to the EAP service from an external service provider. Madam President, I'll close by pointing out to Senator Mark, apart from the support offered to the various divisions through the EAP and other programs for employees, in December 2018, the Minister of National Security formally handed over to the Police, Social and Welfare Association a beautiful facility in Brickfield in Karapichaima for the purpose of finally having a permanent home for the hard-working 2nd Division officers in the country. And that facility will include the development of a gym and facilities to support the health and wellness of the officers. Thank you.
Senator Mark.
Madam President, thank you very much. Madam President, the matter of regular gasoline is a very critical matter affecting the fisher folk of Trinidad and Tobago. The government having taken a decision to deliberately shut down the Petrotrin refinery to allow BP to become the sole supplier of all our refined products, using PDVSA, Madam President, to accomplish this mission, has resulted, Madam President, in a situation where the government is unable to import and to supply fisher folk with regular gasoline. They have literally abandoned the fishing industry in this country, where you have thousands and thousands of fisher folk. Madam President, the excuse of the government is that the 8,000 to 10,000 barrels of regular gasoline imported on a monthly basis is too small in volumes for the government to be bothered with these fishermen. So you know what they have recommended, Madam President? Is like Mary Antoinette when the masses were protesting. Marie Antoinette, when they were protesting in France and they wanted bread, she said, okay, eat cake. So in the case of this government, the local Marie Antoinette, they say, Madam President, instead of using regular, use super. Eat super, use super, madam. But Madam President, what they didn't tell the fishermen, and what they didn't tell the fishermen is that a liter is $4.97, $4.97. You know what it was for regular, Madam President? $2.60 per liter. Look at the big jump. But then this bourgeoisie government does not care about the proletariat and the working class. They don't care about the working people. So, Madam President, the people, the fisher folk, Madam President, are under extreme stress. And they are literally begging the government to reconsider your ill-advised decision to shut down Petrotrin and to consider importing regular fuel. But I want to give them a warning, this government, and I also want to advise the fishermen, time longer than twine. We have already given an undertaking that the new government led by the Honorable Kamala Prasad that will be in power. I am telling you, me and arguing with you, you know. I am telling you that the UNC will be in government. I am arguing that. And Madam President, when it comes, we have already given the fisher folk an undertaking that we are going to revisit that decision of the government to shut down the Point-à-Pierre refinery. So we will get things going, Madam President. Madam President, you know what has been the result of this whole development? The price of fish has gone up enormously, Madam President. It's almost about 70 to 80 to 90 dollars a pound. Yeah, you understand, Madam President? So for kingfish, in fact, somebody told me recently, kingfish is really king now. And that has to do, Madam President, with the government's decision, you know, to actually bring about this situation where citizens who are fisher folk, they cannot, Madam President, access in a proper way, you know, that ability for them to use regular gasoline. So, Madam President, the industry is in crisis. They are crying out to the government for help. They're calling on the government, the Prime Minister, to reconsider their position. I am simply voicing their concerns this afternoon. I am asking this evening, Madam President, I am asking the government on behalf of the thousands of fisher folk for the government to reconsider its decision to abandon them and to reconsider this whole question of regular gasoline. And even if the government, as they remain in office temporarily, let the government and so on take a decision to import, Madam President, regular fuel for the fisher folk so that they can use it. And don't tell me that Tobagonians are using super gasoline. Tobagonians never use regular gasoline for whatever reason. We in Trinidad use, Madam President, the fisher folks, we use regular gasoline in order to go out and fish and to earn a decent living. So, Madam President, I've raised this issue on behalf of the fisher folks, of this country fisher folk, and I'm asking the honorable government, that is through the leader of government business, the Minister of Energy and Energy Industries, to give this parliament an undertaking that the government will reconsider its position and revisit its decision on this matter of abandoning the fisher folk as it relates to the supply of regular gasoline for their vessels. And if you cannot do it, And if you fail to do it, I give the fishermen the undertaking that a UNC government will do it, and they will have regular gasoline in their boats when we return to office. Thank you very much, Madam President.
Minister of Energy and Energy Industries.
Thank you very much. Madam President, I have a response to this question and this motion. But the dilemma of the fisher folks is that if they go to take Senator Mark's promise, they'll wait forever. But having said that, seriously, when we closed and restructured Petrotrin and discontinued refinery operation, it was a decision that has been well articulated, so I wouldn't repeat it. It was in the national interest. We promised the country 3 things specifically. One, that there will be a seamless and a smooth transition in the supply of liquid fuels: gasoline, diesel, and aviation fuel. A lot of hullabaloo was raised, and said they'll have shortage. There was a time when they said the imported super was burning out faster than the super that was produced in refinery. All that has dissipated because there was no scientific basis to that. We have successfully given the country a smooth transition into the supply of fuel. Secondly, we said that there will be no disruption in the supply of LPG. LPG was produced by the refinery. We now buy LPG from PPGPL, which is Phoenix Park Gas Processors Limited. It is important to note that the government now stands in excess of $400 million in the subsidy of LPG per annum. A 20-pound cylinder of LPG that sells in Trinidad for $20 TT. No, $3 transport. Let's put that on the van. It's $20. That is sold, if it's equivalent in Jamaica for 100 TT. 5 times the price. Thirdly, we said bitumen. We have a supply from Lake Asphalt, and we have opened up the market. We have reduced the CET, and the contractors could import their bitumen to continue their road paving exercise. But, Madam President, there has been an issue with regular. We, the government, genuinely sympathize with the fishing community in dealing with that challenge. But the government was left with no other choice but to discontinue the use of regular gasoline. Several factors were considered before making this significant decision. As I have stated previously, regular or Run 83, that is the octane number of 83, was only available in Trinidad with a monthly average volume of between 8,000 and 10,000 barrels per month, as articulated by Senator Mark, being sold by Petrotrin. With the cessation of refinery operations at Pointe-à-Pierre, that small volume is extremely difficult to source on the international market, as refiners do not even produce 183. So here what you have to do. You have 1 million barrels a day throughput refinery in the Gulf Coast of the United States. It is an off-spec product, so they don't make it. You have to go and order 10,000 barrels a month. They will make that for you. And if you know they make it for you, it will cost you £1 and a crown. And to continue making 183 available to Trinidad after the closure of the refinery, it would have to be specially ordered due to the small volume. I'll get more specific. A market survey was conducted to determine the availability and cost of importing unleaded regular gasoline, 183. Due to the parcel size and the specification, only few suppliers were willing to respond due to the custom grade and the ability to segregate small volumes in a refinery, terminal, and vessel. So to segregate it in a refinery is our problem. To store it in a terminal, to ship it. You're taking a 100,000 barrel tank to store 10,000 barrels. But you can't commingle the different grades. No shipping now. You're taking a big tanker. They are segregated in tanks. You're taking a 50 or 100,000 barrel tank to ship 10,000 barrels. It is just grossly uneconomic. We know it will cause some level of hardship to the fishermen and by extension to the community, and it may well affect the price of fish. However, all is not lost. You heard the Prime Minister yesterday at the Energy Conference indicating there are 50 companies that have shown an expression of interest. A request for proposal will be published by the middle of this month. The Oilfield Workers Trade Union has an exclusive period in which to prepare their offer, after which it will be opened to the international community. With 50 expressions of interest and with a new business model, it is very likely, it is extremely likely that we will find a partner or somebody interested in the refinery to operate it under a new business model. The state will not be involved. We will lease it, we will sell it, we will work out some arrangement that will mutually benefit both parties. Some operator may have a source of crude, some may have markets, some may have technology that they could bring, and a new operating environment. So that is how the business has to evolve. And we cannot take these major decisions, multi-billion-dollar decisions, and if there's one fly in the ointment, we just have to know how to take the fly out. Okay, so I feel confident, hopefully by the end of this year, or at a minimum, or at latest early next year, the refinery could become operational again, and this whole issue could have gone long past us. It is not that we don't care. It is the very reason because we care that we have done what we had to do. Okay, and the dust has settled. The nation has seen the wisdom in our decision, and we ask for more perseverance and in understanding what the specific situation is with regular, and we hope that it will be solved in the not too distant future. Madam President, I thank you.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, the 12th of February, 2019 at 1:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, the 12th of February, 2019 at 1:30 p.m.